there are certain sort of, I guess I might call them backwaters of Oregon administrative law dealing with what are called municipal corporations. And this is basically everything that is not an agency under Oregon law. In particular, the municipal corporations are defined as counties, cities, districts, or other municipal corporations or public corporations organized for a public purpose, including a cooperative body formed between municipal corporations. So these are things like water districts and irrigation districts and city municipal corporations and so forth. These entities are not part of the Oregon APA. They're sued instead under a mechanism that's called, it's an old common law writ. It's been converted into statutory form. It's called a writ of review. You can find the statutes dealing with writ of review under Oregon Revised Statute Chapter 34. And then it only applies to actions by municipal corporations acting in their judicial or quasi-judicial capacities. So it's sort of a parallel to the provisions in the Oregon APA regarding lawsuits for, or regarding the judicial review for orders in contested cases or other than contested cases, but applicable to municipal corporations. And this is a sort of a niche area. If you want to know more, it's worth looking at ORS 34 and looking at, for instance, the Oregon State Bar CLE book on administrative law actions. That'll get you a little bit more information about these kinds of writs of review. But it's just worth noting that if you're trying to sue a sort of lower level entity within the state of Oregon, governmental entity within the state of Oregon, you have to be careful to make sure that you're not talking about something that's subject to the writ of review statutes. If it's a legislative action by one of these municipal corporations, then what you have available to you are things like declaratory judgment actions, okay? But again, it's not part of the Oregon APA. The last thing that's worth mentioning is federal causes of action against state entities. And in particular, this is the sort of thing where if a state actor is doing something that's contrary to law, then 42 U.S.C. 1983 provides a possible cause of action against that state actor. Now, there's a huge number of issues that are caught up in this, all of which you would learn more about if you took federal courts next semester. But basically, there's a lot of issues dealing with interpretation of 1983 as to whether or not a cause of action is available. The intersection of 1983 with the 11th Amendment, which precludes suits by citizens of the state against another state, and lawsuits by, and the questions of immunity rules, and in particular, absolute immunity and qualified immunity rules. Absolute immunity apply to things like judicial actions, prosecutorial actions. Qualified immunity applies to sort of everything else. And the general rule there, although again it could go on for a long time, it could be an entire course into itself, is that individuals like police officers cannot be held responsible unless the thing that they did was in violation of clearly established law. There's a huge amount of information there, but those are the considerations that go into 1983 causes of action. The equivalent, if you want to sue a federal entity or federal agency, is what's called a Bivens suit, that basically says that there is an implied right of action under the Constitution to sue governmental actors, U.S. governmental actors who are violating the Constitution. The last point before we get into the heart of reading for today, and I think what I'll do is I'll stop the tape, we'll set up, and I'll set up a second edition, second episode, is the question of attorney fee recovery. The one practical thing that you need to know about trying to get attorney's fees out of litigation against a federal or state agency is that you almost certainly are going to have to plead it at the outset. Sometimes you even have to give them warning ahead of time that you intend to file a lawsuit and seek attorney's fees. So you have to plead it at the outset. That's the practical rule. The legal rule is just you have to find the source for the right to get attorney's fees. It is still a waiver of sovereign immunity question. Just because you're entitled to get money damages, just because you're entitled to get injunctive relief, doesn't mean that you're going to be able to get money or attorney's fees from a federal or state agency. There are a lot of specific waivers of immunity. One of the most important is 42 U.S.C. 1988. If you've got a 1983 lawsuit against a state actor, you may be able to get attorney's fees if you prevail in that litigation. It's one reason why people like to sue under Section 1983 in that kind of a lawsuit. There are specific provisions in substantive statutes. The Clean Air Act, Clean Water Act have provisions allowing for attorney fee recoveries in certain circumstances. There are some catch-all provisions that allow you to recover attorney's fees, but these are very specific. They're not available under the APA generally, but the Equal Access to Justice Act, EAJA or EJA, does allow you to recover attorney's fees unless the government's positions taken in the lawsuit were substantially justified, and that's read pretty broadly. Basically, the government only loses and has to pay fees if the government takes an objectively unreasonable position in the course of the litigation. And they're pretty adept at not doing that if they can at all help it. The other thing that sometimes you get is that some states will permit recovery of fees under sort of common law ideas. If somebody's brought litigation as a private attorney general, basically stepping in for the agency to litigate and enforce statutory or regulatory provisions that the agency hasn't had a chance to get around to. Sometimes they'll allow recovery of fees. It's relatively rare, but it's something that's worth looking into because, of course, if you can get attorney's fees, that's a good way to make up some money for the year and to be able to do something useful while not trying to have to worry about charging clients hourly rates.